A federal appeals court basically saying that participants in health exchanges run by the federal government are not eligible for tax subsidies. This case goes to the heart of Medicare. The decision could mean premium increases for more than half Americans who purchase the taxpayer-subsidized insurance under the law, also now affecting consumers who purchased their coverage through the federal insurance marketplace, or the exchange as it's been called, serving 36 states. But another ruling from a separate federal appeals court in Richmond unanimously upheld the law and its system of subsidies and tax credits. Joining us now to try and make sense of what is happening in the courts, someone who's gone to court on this issue himself, Wisconsin Republican Senator Ron Johnson. Ron, we thank you very much for your time this morning.
Hello, JD. How you doing?
Doing okay. We're going to get to your lawsuit. We're going to press on here. Got to tell you, obviously, your lawsuit is one issue, but before we get to that, let's talk about these conflicting appeals court rulings. First of all, the judges in Washington ruled that the law as written only allows insurance subsidies in states that have set up their own exchanges, invalidating an IRS regulation. If this is upheld, what would it mean for Obamacare and the people who are counting on these tax subsidies?
Well, it just throws the entire healthcare law into just disarray. All these lawsuits are working through the courts, including mine, and we haven't made a decision whether or not we're going to appeal my decision on standing. Really strike to the heart of the problem with Obamacare. It was so sloppily written. What the written law says is not what this administration is implementing. And in this case, in terms of the D.C. Circuit and the Fourth Circuit, both courts came to different conclusions. But from my standpoint, it's pretty clear. It says the subsidies can be paid, to policies purchased on exchanges established by the state. And it's just very clear in its wording. And what we're seeing repeatedly with Obamacare is President Obama, even though his allies wrote it, he signed it, this was his signature piece of legislation, he continues to make changes to the law. He amends it. He delays it. And he does not have the executive authority. He doesn't have the constitutional authority to do so. And that's really what is the heart of these issues. And what we're going to see, J.D., here, particularly on the D.C. Circuit, we're going to find out exactly why Harry Reid dropped the nuclear option on the United States Senate. It was all about packing the D.C. court specifically for this purpose, so that if Obamacare came before the D.C. Circuit, which is frequently the step right before the Supreme Court, he wanted to make sure that he had Obama-appointed judges there to back up whatever the administration wanted to do.
So you have that situation with the appeals court in D.C. Meantime, in Richmond, a decision coming at it from the other direction. In your mind, Ron, does this virtually guarantee that Obamacare heads back to the Supreme Court?
I think it's very likely. Now, both decisions were basically brought forth by a panel of only 3 judges. So it's a possibility that both of those cases will go before the entire courts in both the 4th District and the D.C. District. And that's what I was talking about in terms of why it was so important for Harry Reid to do the nuclear option so that they could pack the court to virtually guarantee an outcome that's favorable to Obama and Obamacare.
So, yes, I believe that would be called an en banc decision if every one of the judges on those particular circuits were called in to hear both cases. But even allowing for that, it is possible we could see a return to the Supreme Court, yet another facet of Obamacare.
Absolutely, and I think there are a couple other cases in different districts also working their way through the other appellate district as well, so or the other circuits. So there's a great, the high likelihood that this will actually go before the Supreme Court, and it should.
Ron, there is always a political aspect to these decisions, and from the White House yesterday, Presidential Press Secretary Josh Earnest remained optimistic after one of the rulings. Let's listen to what he had to say, then we'd like to get your reaction after we hear this. Take a listen.
There's a lot of high-minded case law that's applied here. There's also an element of common sense that should be applied as well. which is that you don't need a fancy legal degree to understand that Congress intended for every eligible American to have access to tax credits that would lower their health care costs, regardless of whether it was state officials or federal officials who were running the marketplace. I think that is a pretty clear intent of the congressional law. This will work its way through the legal process, and we are confident in the legal case that the Department of Justice will be making.
Ron, your thoughts on what Josh Earnest had to say?
You know, JD, I wasn't here when they actually wrote the law, but my understanding of why they put the incentive through the state exchanges for the subsidies is to entice the states to actually establish their own exchanges. So, no, Congress specifically wrote the law that the subsidies would only flow through state exchanges. That was the inducement. That was the incentive for the states to establish those exchanges. I mean, that was clear. So, no, I mean, I think they are revising history here for their own political purposes. But, you know, again, the language of the law is quite clear in a number of circumstances where this president has unilaterally changed the law.
Well, we heard that expression of optimism from the president's press secretary. Meantime, the president's old law school professor, Lawrence Tribe, was more pessimistic. He's been quoted as saying he wouldn't bet the farm on Obamacare's survival in the courts. Who do you think has a more realistic take on this?
I wouldn't bet the farm on it either. And, you know, JD, kind of during the 4th of July recess, President Obama gave a speech, you know, talking about how, listen, you know, I'm going to take executive action. These problems are so serious, and if the Congress doesn't like it, they can either pass a law or they can sue me. The reason President Obama could utter such an arrogant statement is demonstrated in what happened in court in Wisconsin last week when I was not allowed to have the merits of my case heard because my case was dismissed because of standing. It's very difficult for members of Congress to challenge an administration, show specific harm, to actually rise to that Article 3 standing to have your case heard. And so President Obama is very arrogant about that. So he will continue unless he is stopped, unless he is checked, unless the judiciary actually does engage in these separation of powers disputes. He will continue to be this arrogant. He will continue to govern unilaterally, unconstitutionally, and that threatens everybody's freedom.
And Ron, since you brought up your suit and the fact that it was dismissed, your political opponents in the Senate and elsewhere are calling it, quote, a political stunt. Respond to that charge, and also a little more insight. Is it possible, we've got about a minute left, do you think you're going to go ahead and appeal that ruling on standing?
We're going to talk to my legal team here this afternoon to make a decision on making an appeal. But no, my lawsuit is by no means a stunt. The language that I'm challenging, the rule I'm seeking to overturn, again, was very clear. Congress wanted to put themselves in the exact same position, be treated equally under the law when they wrote the law to get it passed. But then, you know, when the law was actually being implemented, this isn't going to be very good for us to have to buy our policies through the exchange and not get a federal employer contribution. So no, again, the law is very clear. The only reason I can't challenge it, the only reason I can't get a court to overturn it, is I am having a difficult time showing the court that I've been specifically harmed. And again, that's always going to be the case, which is why President Obama can be so arrogant and just say, sue me. I'm going to continue to act unilaterally, unconstitutionally, sue me. I mean, the arrogance is jaw-dropping.
Well, Ron, you may have had difficulty in front of the court, but no difficulty this morning outlining your position and your informed analysis on where Obamacare may be headed. Ron Johnson, Republican of Wisconsin, we thank you for your time this morning from the U.S. Senate.
Have a great day.